There are three really important contributions that including a provision on children's rights in a constitution can make. The first is that it serves to legitimise children's rights. Adults usually have constitutional rights, so giving children a specific provision in a constitution that recognises that they too hold constitutional rights legitimises children's rights. It makes them more acceptable in political discourse, in legal discourse, and emphasises the fact that children as well as adults are holders of human rights and constitutional rights. The second is that it elevates children's rights to the highest level of protection in the legal system. This means that they are harder to erode. We know that constitutions are difficult to change. They are more difficult to change than other types of law. And so including protection in a national constitution for children's rights makes it more difficult for those rights to be eroded over time because of changes in political priorities or other issues like that. It also allows people to take cases to court because constitutions are usually the supreme source of law in a legal system. And so when you protect children's rights in a national constitution, you allow people to take cases to court seeking to invalidate legislation or policies or other forms of law which are contrary to children's rights, which can achieve very powerful outcomes, not just for the child who takes the case, but also for other children affected by that law. And then the third important contribution is that giving children constitutional rights acts as a counterbalance to constitutional rights given to other parties, adults or parents or families, which can, in rare cases but very important cases, sometimes be exercised in a way that can be damaging to children's rights. So if adults assert a constitutional right which enjoys the benefits of entrenchment and supremacy in a way that is harmful to children's best interests, then it can be the case that unless children also have constitutional rights, that the court has no choice but to uphold a decision of adults which might actually be harmful to children. Whereas if children also have constitutional rights, then that strengthens the position of those rights and acts as a balance against the adults' rights. The challenges are, first of all, that developing constitutional rights for children is a very slow process. It takes a very long time. And secondly, that you have to be very careful in how you write a provision on constitutional rights for children. Because it's not enough simply to say something about children in a constitution. You have to draft the provision in a way that reflects the child rights approach that's set down in the United Nations Convention on the Rights of the Child. And in order to do that, you need to include in the Constitution a provision that includes a high level of visibility for children's rights so that they're mentioned in a detailed way. You need to achieve high levels of agency for children in a constitutional provision so that you don't see them simply as objects of protection and view them in a paternalistic way, but also as being independent rights holders. And finally, those rights must have a high level of enforceability so that children can seek remedies to vindicate their rights in circumstances where their rights are violated. And if a provision doesn't achieve those three things, well then it will fail to achieve the full potential that children's constitutional rights can have.